my second thought is that despite the fact that the criminal code provisions against physician-assisted suicide have been struck down, Section 241B, Section 14 of the Criminal Code, the history of the medical profession remains, and it is deeply entrenched in the minds and the hearts of many physicians across the country. The Hippocratic Oath, for example, which is millennia old and still remains in use in various variations across North America today. While it has been discarded in some jurisdictions, yet the Hippocratic Oath remains in use, and it specifically prohibited giving a patient poison or counseling another person to do so. So there are strong conscientious and religious objections that are held by many, many physicians across the country. And erasing two sections of the Criminal Code do not erase the way they feel about it and the way they believe about it. We submit that the new federal legislation should provide explicitly that physicians, nurses, pharmacists, and other healthcare workers, as well as healthcare organizations and institutions, can refuse to participate in and refuse to refer for physician-assisted suicide. The Supreme Court of Canada decision in Carter in no way compels doctors or other healthcare workers to cooperate unwillingly in a physician-assisted suicide scenario. Carter was predicated on two key factual conditions: a willing patient and a willing doctor. None of the scenarios before the court in Carter involved an unwilling doctor. The existence of a right of patients to require every physician to refer for every medical service is a misconception that some of the provincial colleges of physicians, as well as the Canadian Medical Association, appears to be laboring under. Many doctors and other healthcare workers are object to assisted suicide on ethical, moral, or conscience grounds, or on historical grounds for their profession, which does not negate the fact that their objection is one of conscience. The Supreme Court of Canada in R versus Big M Drug Mart made these comments. Freedom can primarily be characterized by the absence of coercion or constraint. If a person is compelled by the state or the will of another to a course of action or inaction which he would not have otherwise chosen, he is not acting of his own volition, and he cannot be said to be truly free. Coercion includes indirect forms of control which determine or limit alternate courses of conduct available to others. Our second recommendation is that Parliament should enact legislative protections for medical practitioners in a substantially similar fashion to those contained in the Civil Marriage Act. In the Civil Marriage Act, specific protections were enacted for individuals and organizations who have a religious or a moral belief that marriage is between a man and a woman to the exclusion of all others. No citizen, because of the Civil Marriage Act, can be sanctioned for expressing or propagating or advocating for the belief that marriage is between a man and a woman. The legislation specifically states that it is not against the public interest to hold or advocate these beliefs. We submit that this is an analogous situation. There is a jurisdictional overlap between the federal government and the provincial governments, and it brings it into line with the Civil Marriage Act situation. Parliament should note that constitutional infringements are already occurring or already suggested to occur in the guidelines that are being released by the colleges of physicians across the provinces. It would be worth noting that the Canadian Medical Association has essentially said that there should be a requirement to refer. It does not consider the referral for physician-assisted suicide as assisting in physician-assisted suicide. Additionally, it seeks to qualify the rights of physicians with respect to a delay component or a time component. In our respectful submission, there needs to be a careful balancing of the rights of physicians versus those of patients, because the non-autonomous nature of a patient who requires the assistance of a physician calls into question the rights of the assistor.